Ever wondered about the legal complexities surrounding the world of cryptocurrency? Specifically, what happens when the U.S. Securities and Exchange Commission takes a crypto giant like Binance to court? Let's dive into a recent ruling that has everyone talking. The ruling, federal judge Amy Berman Jackson recently ruled on a case involving the SEC and Binance. The judge decided that most of the SEC's allegations against Binance US, and Changpeng Zhao were plausible, dismissing only certain charges related to the sale of BUSD, secondary sales of BNB by sellers other than Binance, and Binance's simple earn product. Why it matters. One key issue at hand is whether secondary sales of cryptocurrencies can be considered investment contracts under securities law. This question remains unanswered by appeals courts, making this ruling is particularly significant. Breaking it down, Judge Jackson's ruling largely maintained the status quo in litigation around crypto and securities. She ruled that the major questions doctrine did not apply, that the SEC's arguments were mostly plausible, and that there was a reasonable case to be made based on the facts as alleged. However, the judge's ruling on secondary sales by sellers other than Binance and stablecoins, specifically the USD, has been hailed within the crypto industry. The judge pointed to transcripts from various hearings, noting that SEC attorneys seemed to still take the position, but if a token's initial sale carried marketing materials, suggesting it was a security, those factors will continue to apply through future sales. The Howey test and secondary transactions in Judge Jackson's ruling emphasized the role of the Howey test, and that the question around secondary transactions is facts and circumstances based. However, she also noted that more is needed to support the SEC's arguments about ongoing sales of tokens. The broader context, and of course this ruling doesn't exist in a vacuum.
The U.S. Supreme Court recently published 3 significant decisions that may affect the crypto industry's relationship with federal regulators. These include the overturning of the 40-year-old Chevron deference precedent and a ruling that there is no statute of limitations on when private parties can sue a federal agency's rulemaking.
And with that said, thanks for watching, and until next time. And remember, just like a good joke needs a setup and a punchline, a good understanding of crypto law needs a solid grasp of the facts and the context. Stay informed, stay curious, and keep laughing.